Hello, everyone. My name is John Machell, and it's my pleasure to welcome you to our Searle Court and Maples and Calder panel session on the Bermudian Court of Appeal decision in Grandview and Wong and its ramifications for trustee decision-making. I'm very pleased to have with me today three of the leading practitioners in this field: Jennifer Haywood of Searle Court and Ray Davern and Alex Way of Maples and Calder. I think it's probably stating the obvious to say that many aspects of a trustee's job involve the making of decisions. Some are obviously day-to-day decisions. Should trust funds be invested in a particular asset? Should an asset be sold? Should a director of one of the underlying companies in the structure be removed? Some are going to be more fundamental. So, for example, should distributions of capital be made to particular beneficiaries? And some are going to be existential. Should the trust be resettled or should it be wound up? And of course, when making decisions, trustees have always been concerned to ascertain that they have the power to do what they're proposing and to be satisfied that the decision is an appropriate one for them to take. But in our experience, trustees are coming under increasing scrutiny these days from beneficiaries who seek to second guess or challenge discretionary decisions. And what we want to do today is discuss the way in which the law in this area is developing, and also to give some practical tips and guidance for trustees who are seeking to avoid the wrath of their beneficiaries. So to start us off, Ray, why don't you tell us a bit about the Bermudian Wong decision?
Thanks very much indeed, John. Morning all. The Wong decision is a recent decision of the Bermuda Court of Appeal, in which the leading judgment was given by Sir Christopher Clark. Supporting judgments, the judgment was unanimous, given by Justices of Appeal Smelly and Subair Williams. The matter came before the court under the Bermuda Supreme Court Order 14, so a summary judgment application, and the decision at Court of Appeal level is a decision in favour of the respondents to the summary judgment application. And in the end, it is a decision overturning Mr. Justice Caverley at first instance that a particular point, which I will outline shortly, is properly arguable as a matter of Bermuda law. The decision is one of Bermuda law, but of great interest for obvious reasons, particularly given the eminence of the tribunal to all offshore trust lawyers, and in particular to those in the Guy and Cayman who have similar purpose trust legislation. The exercise of power, the point in question was whether an exercise of a particular power set out in a trust instrument was valid. The trust instrument was or declared a discretionary trust in 2001. It was called the Global Resource Trust, referred to in the judgments as the GRT. And the power in question was a very widely framed power to add or exclude any person as a beneficiary of the trust. And that was contained in Clause 8 of the GRT. The power was used in 2005 to add the trustee of a Bermuda purpose trust set up by the same economic settlor as the GRT, called the Wong Family Trust. That trust was a perpetual trust, and in 2005, the trustee of that trust, which was Grandview, a Bermuda private trust company, was added as a beneficiary in its capacity as trustee of the Wong Family Trust. In the same act, the existing beneficiaries of the GRT were excluded, and all the assets of the GRT were then paid or transferred over to Grandview as trustee of the Wong Family Trust. And so the net effect of the 2005 transactions or dispositions was that all the assets of the GRT were in effect appointed, paid or transferred over to Grandview as trustee of the perpetual Bermuda Trust. Amongst other things that arose for decision in the case, which I won't look at today, was a perpetuities point concerning the rule of remoteness of vesting. But the point that I will be looking at in this short introduction is that a principal challenge to the 2005 Act was that the exercise amounted to an invalid exercise of power, in particular that it amounted in substance to the exercise of the power of amendment, and the GRT also had an express and widely framed power of amendment, that the exercise of powers of amendment was subject to a rule called the substratum rule. That is to say that a power of amendment can't be used to destroy the substratum of a trust, however you identify that. At Court of Appeal level, that central claim failed. I'll look at why in a moment. Just a little bit more of the factual background to the two trusts. Both trusts were set up by two Taiwanese entrepreneurs. They were referred to in the judgments as the founders. And certainly by 2000, they had founded a group called the Formosa Plastics Group in Taiwan. And by 2008, that was one of the biggest conglomerates in Taiwan, and worth hundreds of millions of US dollars. In 2001, as part of the founders' estate planning, that is to say, deciding which of their children got what upon their death, the GRT had been formed as part of their estate planning, and £90 million worth of shares in a company called Grid Investors had been put into the GRT. And so that was the provision back in 2001 for effectively the family, but whether that could be changed was, of course, the issue in the case. The Wang Family Trust had about, when set up, about over $500 million worth of assets in it. And that was a trust from which the Wang family, in the general sense, could not, in fact, benefit. It was a Bermuda mixed commercial and philanthropic purpose trust. And as I say, the trustee of that trust was Grandview. Quick bit about some of the terms, key terms of the GRT trust. Firstly, it defined the beneficiaries thereof as various descendants of the founders, but the definition was expressed to be subject to any exercise of the Clause 8 power to add or remove beneficiaries. There were typical, in terms of offshore trusts, and typically wide discretionary dispositive powers set out in clauses 3.1 and 4.1, which allowed for the transfer, payment or application of the fund on further trusts, including discretionary and administrative powers and so on. There was a fairly standard, in offshore terms, default trust for the descendants of the founders alive at the end of the perpetuity period, which was expressed to be 100 years. And then there was an ultimate default gift over to charity if all the other trusts failed. Clause 8 itself was a power to add and exclude beneficiaries. And in terms of the power to add, which was the key power really being analysed in this Court of Appeal decision, and the power was expressed to be one to add any person, and person was expressly defined very widely to include, amongst other things, a person acting in a fiduciary capacity. Clause 9, which I don't think I need to concentrate on, allowed that any exercise of power to apply income or capital could be exercised by appointing to the trustees of another trust. The Court of Appeal held that that power wasn't exercised, so it's not going to be relevant to what I talk about. Clause 10 had a very wide power of amendment. Clause 23 stated, as is just boldly, that the trust was irrevocable, and Clause 15 had the typical phrase, clause that all discretions are absolute and unfettered. So that description will be familiar to all offshore trust lawyers, that description is of a trust that is exceedingly common in the offshore world. In the 12 years or so that I've been offshore advising on trusts, I must have seen certainly hundreds, maybe something into 4 figures, but certainly hundreds of trust instruments that look substantially identical to the GRT. That is to say, a very widely drafted, very flexible discretionary trust with powers to include and exclude beneficiaries, and seemingly designed to give maximum flexibility to the trustees to achieve set law wishes. So the decision itself, overturning Mr. Justice Cayley, as I say, first of all, rejected the idea that the power to add the beneficiary in this case, the trustee of the Wong Family Trust, was in fact an exercise of the Clause 10 power of amendment. That's the first point. It just wasn't. The Clause 8 power must have been, must be regarded as a power that was designed to give or to do something additional to the power of amendment. Indeed, Sir Christopher pointed out that in England, it was not clear that the power to amend would allow additional removal of beneficiaries, and so the power could be seen as giving that power over and above the power of amendment. And that first step in the reasoning is key, because that allowed the court then to look closely at the Clause 8 power. And taking as their guide Lord Walker's analysis in Pitt and Holt, Sir Christopher in particular referred to threefold thematization of Lord Walker concerning the exercise of powers. One, the first question being its ambit, which is purely a matter of construction. Secondly, the question of deliberation, rational exercise, and so on. That wasn't at issue in this case, but maybe later in litigation in this case. And thirdly, very much an issue in this case, whether the power was exercised for a proper purpose. Sir Christopher classified the power as an intermediate power in the terms of Mr. Justice Templeman in Re Manistee. That is to say, it's not a general power to add anyone, nor is it a special power to add anyone within a specified class. It is somewhere in between, being a power to add anyone except those within a special class, and here the exception was the trustee. So taking those 3 points, or rather the first and third points in turn, the court dealt very shortly indeed with the first point. That is to say, did the power to add a beneficiary, which is the key thing at this point of the litigation, did the power, as a matter of construction, allow to happen what happened? That is to say, the addition of Grandview as trustee of the Bermuda Purpose Trust. Now, subject to any remoteness of vesting points, Sir Christopher dealt with it in one short paragraph. It was very clear that the power, that what was done was clearly within what was deliberately designed to be a very wide power. The use of the word any meant exactly what it said any person could be added, and there was no requirement that if a trustee was added, that it was the trustee of a trust that had some relationship to the existing beneficiaries. So that's the first part of the decision. The next part of the decision, the key bit on proper purpose and substratum, and the court followed the view of Lord Sumption in the Eclairs group case, that examination of proper purpose is not to be reduced to the question of construction. It is a substantive rule of equity. It may be applied or have effect in ways very differently, depending on whether you're dealing with a commercial trust, a pension trust, where the beneficiaries are also contributors or settlers, and non-commercial contexts where the beneficiaries are pure objects of bounty. They get merely what and as little as they are given. In particular, Sir Christopher thought that in a non-commercial context, that is to say a family trust, giving effect to settlers' wishes would not generally be contrary to the purpose, the proper purposes rule, or the fraud on the power doctrine. he thought that if there was a substratum rule, as the plaintiffs in the case had suggested, if there was a substratum rule, which was merely another way of saying what the proper purpose rule did, then it added nothing and could be disregarded. And that substantially is the approach taken by the court, very much encouraged by what Lord Hoffman had said in the Serco and Lawson decision. You have to be very careful about the use of metaphors, and the substratum rule was here analysed as a geological metaphor, which, being such a metaphor, can lead astray. Sir Christopher noted that the substratum rule, as it was called by the plaintiff, had not appeared in any English appellate case, and in all the cases in which it had appeared or been discussed or applied, none had had a power like Clause 8 in it, which on its face seemed to allow the trustees to add any beneficiaries and indeed remove any beneficiaries. The court ruled that the economic settlor should be assumed to have intended that the power, and this is what the court said, can be used to do what it says, that is to say, add any beneficiary. Also, the court said that if substratum does apply, and it was of the view that it didn't, the substratum or the core, whatever it is, of the GRT trust was to benefit the beneficiaries of the trust as they may be from time to time. And so in order to say that this is a family trust for the descendants of the founders, and therefore any exercise of the power to add would be contrary to that substratum, was in fact circular. It relied on what it needed to prove, which is that the power couldn't be exercised so as to increase the beneficial class. So even if substratum applies, the court was very clear that the core of the trust, whatever that means, again, core is a sort of geological metaphor, I suppose, the core of the trust is benefit to the beneficiaries as they may be from time to time. And the court took some comfort, I think, from the 19th edition of Lewin, in which the learned editors of that work expressed the view, commenting on substratum, that the settlor's wishes from time to time, the subjective expression of their wishes from time to time, and not merely at setup, would or could be relevant. And for that proposition, or that proposition, they relied on what Lord Walker had said in Schmidt and Rosewood to almost precisely that effect. And as I say, the court also relied on the decision of Mr. Justice Templeman in Remansty, where again the court had also expressed the view that the trustees, when deciding how to exercise an intermediate power, would be entitled to and possibly should consult should inform themselves with regard to the settlor's wishes, howsoever required. And so the substratum rule, according to the Court of Appeal in Wong, does not exist. If it does, it doesn't apply to any significant degree to a trust that has a widely added clause like Clause 8 to add and include any beneficiary. And as a result, the matter is on its way to the Privy Council, and we'll have a discussion in a bit, I hope, about what the chances of each of the parties is before that tribunal.
I suppose no webinar is complete without somebody trying to speak when they were on mute. Thank you very much, Ray. That was very interesting. I remember thinking when the first instance decision came out that it had the potential to be utterly terrifying, excuse my melodrama, but utterly terrifying for the offshore trust world, because it seems to me that one of the obvious points to make is that the offshore wealth management industry promotes trusts like you've described, Ray, by reference to their very flexible and wide-ranging powers. And I would have thought a sort of thinking person settlor would be slightly surprised to have been told by Justice Caverley at first instance that despite the trust having a power to permit a trustee to add anyone as a beneficiary, that was in some way limited in terms of scope. And again, I would have thought a thinking person settlor might pause for thought as to whether doing what the trustee did in this case was a proper exercise of the power, which we'll come on to. But as a matter of the scope of the power and what the trustee was permitted to do, I remember thinking that the first instance decision was quite surprising. And I would have thought the offshore world would take some comfort from the Court of Appeal decision. What do you think? What's your view of the chances for the family and the Privy Council?
Thanks, John. So, like you, being part of the offshore trust industry, I agree that these trusts are promoted by onshore counsel, who instruct us to set them up and advise on their terms, precisely because of their immense flexibility under the statutory regimes of the various offshore jurisdictions. So they very much are promoted on that basis. To me, one of the things, and I say this with great respect, that is remarkable about the judgment is its relentless logical rigor, particularly the judgment of Sir Christopher Clark. I would say that judgment would be very hard to impeach before the Privy Council. I say that because of its rigor. It deals comprehensively, I think, with the circularity of the plaintiff's argument. But it's also part of what I think is an encouraging trend as regards the way the Privy Council is beginning to look realistically at offshore trusts. So Schmidt and Rosewood was in many ways a very good decision for offshore trusts. Lord Walker's judgment looks very practically at how trustees with these very wide powers should go about exercising them, and they may take account of settlor expressions of settlor intentions that aren't simply evident from the document or prior to the execution of the document. But I have also in mind the decision of the Hong Kong Court of Final Appeal in the DBS case, maybe 2 years ago, where looking at anti-Bartlett clauses under, that was a Jersey law trust, but looking at anti-Bartlett clauses, again, the approach of the court is, so far as possible, and so far as not inconsistent with the core doctrines, the irreducible core content of trusteeship and of what a trust is, so far as possible, we give effect to trust instruments according to what we say. And that's very much, I think, the policy that drives the DBS decision. And it was fascinating for me to see Sir Christopher Clark say that so clearly in his judgment. The question of construction about the power to add was, you take the words as, there's no equitable trick there to catch settlors out or trustees out. So a decision that the offshore world will welcome greatly.
I agree. And I think the Privy Council might take the opportunity to say something about the distinction which seems to me to exist within the proper purpose doctrine, between the proper purpose doctrine as a tool for limiting the scope of a power, which is really what was in issue in this case on the one hand, and proper purpose in the subjective motive sense, which is what really Lord Sumption was dealing with in the Eclairs case to which you referred earlier. So there are some of the justices, particularly Justice Sales, is quite interested in this particular point. It's quite a nerdy one, and he's written extrajudicially about it. And I suspect if he's on the panel, he'll have something to say about that. But in terms of overall result, I absolutely agree. I would have thought the family have got an uphill struggle. Of course, the second stage to the litigation, to which you alluded, is the separate question about whether the trustee was entitled to make the decision it made, not in the sense of scope of power, but whether it was an appropriate decision. And that really takes us on, I think, to that second point. And trust law really on this second question has historically tended to focus on the good faith of the trustee and whether it has acted for a proper purpose in what I just described as the subjective sense. There's also, of course, some reference to taking into account relevant matters and ascertaining facts, but that, to my mind, has been really quite secondary, and it's always been historically very hard for beneficiaries to challenge discretionary decisions. But there have been a number of English cases decided over the last few years where the courts have investigated really the extent to which concepts of good faith affect commercial discretionary decision making, and also have examined the extent to which public law principles can, by way of implication, affect the exercise of commercial discretions. And so, Jennifer, why don't you tell us a little bit about what you think there may be in terms of influence of those decisions on the development of trust law in the kind of area that we've been talking about?
Thanks, John. Well, the leading commercial case in this area is Braganza and BP Shipping Limited, which is a 2015 decision of the Supreme Court. And the case involved an employment contract that paid a death in service benefit unless the employee had committed suicide. The claimant's husband had been employed by the second defendant as a chief engineer on board the first defendant's vessel. He disappeared overnight mid-Atlantic. The second defendant's investigation team ruled out foul play and reported that it was more likely that he'd committed suicide than fallen overboard accidentally. On the basis of the report, the second defendant's general manager decided that for the purposes of the death in service benefit in his employment contract, he had committed suicide and no benefit was payable. Now, the trial judge found that that was unreasonable for two reasons. First, he said the investigation team had failed to take into account the possibility that the deceased had gone on deck to check the weather conditions and had simply slipped and fallen. And secondly, he found that the general manager had failed to direct himself that there should be cogent evidence commensurate with the seriousness of a finding of suicide before making such a finding. The Supreme Court held that where one party to a contract had a power to exercise a discretion or form an opinion as to relevant facts, and that party's decision would affect the rights and obligations of both parties, the court would seek to imply a term, in appropriate cases, that the powers should be exercised not only in good faith, but also without being arbitrary, capricious, or irrational in the sense it is applied in the public law line of authorities, or what's known as a Wensbury sense. And there are two elements to that Wensbury test. A public law decision, and following Braganza, many contractual decisions, may be impugned, firstly, where it's one that no reasonable decision maker could have reached that decision, and secondly, where the decision-making process had failed to exclude extraneous considerations or to take account of all obviously relevant ones. It seems to me there's no obvious reason to take a different approach to decision-making in a trust context. This is not the court supplanting the decision maker and making the decision for itself. It's simply a question of whether the standard of review in a contractual context or in a trust context should be less demanding than in an administrative action. And in Braganza, the Supreme Court noted that whilst the courts had been reluctant to adopt the principles of public law in a contractual or commercial context, in practice it had actually been very difficult to articulate precisely what the difference might be. Now, as John's mentioned, in a trust context, it's already well established that a trustee's decision can be set aside if it has not been exercised for a proper purpose, or if the trustee has failed to give proper consideration to relevant matters. We've got the line of authorities that led up to the Supreme Court decision in Pitt and Holt, which make that very clear, for example. And the outcome or rationality test in Braganza reflects the need for the decision to be consistent with the contractual purpose. So one would expect that it to be possible to review a trustee's decision both on the rationality basis, i.e. that the decision has to fall within the range of reasonable decisions that decisions that reasonable trustees could make, so to have an outcome test, but to also have a process test, that the trustee has got to have taken into account relevant matters and have left out of account irrelevant matters. And I think we are actually very much moving to a situation where that's accepted. So in British Airways Pension Scheme Trustee Limited and Fielder, a case where in that case, the judgment just started by noting that the parties weren't even disputing that, and it was common ground, that the test, certainly when the court was considering a blessing of decision, was that the trustee had properly taken into account relevant matters and not taken into relevant matters to start with. And second, was the outcome one which a rational trustee could have come to? And as I say, in my view, there's no logical reason to apply a different way of scrutinising or testing decisions to private trusts, given the established requirements that the exercise of a power is for its proper purpose and that a trustee has got to take into account relevant matters. There might be argument about what are relevant matters in any particular situation, but that's got to be the basic test. I think the second element of the decision of Braganza, which may be of interest to professional trustees, is that, in fact, what made the difference on the facts of that case, where the court was clearly trying to help the widow out, I think, was the finding that where the decision maker was an employer, it would be expected to be aware of the correct approach to the making of any decisions it was required to make. And so it was really key that the general manager had failed to direct himself that there should be cogent evidence commensurate with the seriousness of a finding of suicide before making such a finding. And you can see the scope for similar arguments being deployed in a trust context, that a professional trustee should be aware of the correct approach to the making of any decisions and of various factors that might well be relevant or considered relevant, certainly by the beneficiaries.
I've done it again. Thank you, Jennifer. I agree with all of that, and it does seem to me that the way in which the law is going to develop in all likelihood in this area is going to be by reference to a greater focus on process, and whether one calls that a sort of natural justice requirement in circumstances where trustees are making important decisions affecting the financial livelihood of the beneficiaries, or whether one talks about it in terms of taking into account relevant matters and leaving out of account irrelevant matters. The focus is on the process and not necessarily just on the outcome. And traditionally, of course, the law has stood against the idea that trustees are required to give reasons and even document reasons, both so far as the process is concerned and their ultimate decision. Do you have any thoughts on where trust law might move in relation to those kind of issues?
Yes, I think there are two areas in which I think there's going to be quite a lot of movement. I think the first is, as you said, in the past, the court's been very defensive of trustees. And for example, when trustees have made appointments, they've said there isn't any need or any requirement on the trustee to sort of take active steps and to go out and make inquiries. So if the trustees are making an appointment to one beneficiary on the ground of need, they're not under any obligation to ascertain the needs and requirements of the other beneficiaries. Decision in Hayes settlement, and there's that's certainly sort of been the orthodox English judicial line. I think it'd be very unwise for trustees to rely on that principle now. I think there is an increasing expectation, particularly when professional trustees are involved, and also depending on the amounts at stake, for the courts to expect a process to be followed. And I think trustees are going to be increasingly asked to explain why it wasn't reasonable actually to make some inquiries, or at least ensure that they were in possession of what the key facts are. And whilst there's always going to be scope for for understanding what the facts are. Given that in many trustees, a key factor is going to be following the settlor's letter of wishes and trying to implement the settlor's wishes, you've got to at least put yourself in a position to have some of the information that the settlor might have. So I think there is going to be an increasing move towards expecting trustees to follow a process. I think though there's also a real possibility that the law is going to change around the obligation to give reasons. In Wilson and Lord Debenture Trust, which was a 1994 decision, Justice Ratty held there that a trustee is not required to give reasons for the exercise of a discretion, and emphasised that unless you've got evidence that there's been impropriety, the court's not going to interfere. And what's perhaps really surprising about that decision is that he said it doesn't matter that it's a pension trust, which is slightly odd because the beneficiaries there have obviously given something in return, very often for the pension. And secondly, in Breakspear and Ackland, 2009 decision of Mr. Justice Briggs, as he was then, he emphasised the inherently confidential process that is the process of making discretionary dispositive decisions. And so a trustee couldn't ever be expected to divulge the decision-making process. Now that is at odds with a move towards with an increasing expectation, I think, that principles of natural justice be applied certainly in contractual situations. So in decisions such as DIMOC and the Dance Movement Psychotherapy UK Limited, where that involved excluding a member from a company promoting dance psychotherapy, there the court said, not only is it about the court taking into account the relevant matters, the rules of natural justice also require stating your reasons and giving somebody the opportunity to be heard if they're going to be affected by it. So there is a tension there between a very much cards on the table process that is increasingly becoming the norm in a commercial context, and the very tightly guarded discretionary process that goes on in trust. Now, one can see that there are reasons for maintaining confidentiality in a family trust context. The settlor might wish to keep his true intentions slightly hidden from the beneficiaries, and particularly historically, trusts were often used in the past to benefit people in a much less sort of transparent way. I can't see why that should apply in a pension trust situation. And I think in family trust situations, that might, the expectation would be to decide that very differently today. And certainly if the court is going to be blessing a decision in advance, they will expect a degree of consultation very often, I think.
Thank you. I agree with all of that. And I suspect that many offshore courts may feel driven to defending orthodoxy on these issues, but I can see that they are going to come under increasing strain, certainly in the Privy Council and the Supreme Court. And again, justices, I think where they come from a background of a sort of mixture of public law and commercial law would find some of these principles quite surprising. And one in particular, I think, is around letters of wishes and their influence over the years. And it seems to me one of the things that's going to come under pressure is the idea that a letter of wishes may be prepared by a settlor at the time that the trust is set up and then not renewed. The extent to which maybe 30, 40 years later after his or her death, that can really still have the weight that many trustees think it ought to have. And I think that could come under strain.
I think one of the oddities actually in the cases here is that defensiveness of the confidentiality of the process, and also that sort of implication, well, that the beneficiaries are volunteers, so they haven't really got any right to be involved in the process. The difficulty is the settlor, though, is the person who set up the trust and handed everything over, in the expectation that the trust will be properly carried out. and the trustees, do their job properly. And if you don't have any sort of procedural limits to that, or any way of properly scrutinising the process, it seems to me you're letting the settlor down and betraying the very concept of a trust and the court's inherent jurisdiction to supervise a trust and ensure that the trustees are acting properly.
Yeah, thank you. So Alex, where does this leave our poor unfortunate trustees on the ground trying to do their best? What do you think about sort of practical tips in the current situation?
Well, I think it's obviously a tricky job being a trustee, isn't it? And it's you've got inherent tensions there. I think what this all shows is that it's increasingly important for trustees to understand fully the terms of the trust which they're administering. So in the Wong case, the fact that any meant any, actually, to really understand that what powers you have and the extent and scope of those powers, because obviously part of that is if you're not exercising the powers properly or in a correct and extent way, then you're holding yourself open for challenge. And I think increasingly I guess in terms of practical steps, it is important for the trustees to be aware of the fact that their decision making may be called into question, and they may have to evidence the decision making they've undertaken. And so to actually have a formal method in which to work through that decision making. And so that, on one basic level, that's simply a question of formally recording in a minute the minutes of the meeting of the trustee, who was present, were there any conflicts of interest, what was the decision taken, what were the main factors and reasons in taking that decision, were there any factors that were considered irrelevant or deliberately not considered for that purpose, what advice was taken and from whom, and was that advice followed, or was it different? Did the trustees depart from that advice? And whether there was any disagreement amongst the trustee board itself as to the decision taken, and one of the trustees wanted to formally record the fact that whatever decision was being proposed wasn't what that trustee had in mind. And I think that on one level just goes to good practice in discharging your duties in an appropriate way, but also being mindful of the fact that if you are called to question many years down the line, at least there's a record of what happened. And I suppose another point that Jennifer picked up on is the need to understand what the settlor's wishes are and how those have evolved over time, and particularly what the rationale behind setting up the trust was. If the settlor is no longer alive, it may well be there's no formal wishes in place, but there may still be institutional evidence and knowledge as to why the trust was set up in a particular way. And I suppose a practical example we've got, we've seen is where trusts are set up with particular restrictions put in place by a settlor for a particular fact situation at that time, but 5-10 years down the line, actually that's not appropriate anymore, and people are trying to scrabble about trying to work out why was that put in place. Was the settlor saying under no circumstances should that ever be changed, or was it were there reasons why they're there which are no longer relevant for tax reasons, or that financial situations have moved on. I suppose another practical point that you often see trustees sort of falling foul of is the fact that they essentially there's an element of sort of a rolling decision making being taken, where a particular set of situations have arisen, and so you administer the trust in a certain way, and you don't then revisit and step back as to why, for example, you're retaining this asset or not or haven't promoted that particular asset. And that could be a particular issue where, in an offshore context, where trustees often change relatively, can change relatively frequently for a number of reasons, because the settlor's fallen out with the trustee provider. There's been an issue over fees, and so the new trustees come in and don't really sort of, step back and kick the tires and work out what's going on. They just accept the status quo, and that again is, those trustees are at risk of a challenge for not having exercised their powers in an appropriate and proper way. It's obviously important, critical for trustees, particularly sort of following Pitt and Holt, to take proper and formal advice, but to obviously be mindful of the fact that the advice they take is simply that, absent the terms in the trust deed accordingly, that it's for them ultimately to make the decision to document that decision accordingly. I think, I suppose, hand in hand with making decisions is also entering into a dialogue with the beneficiaries and making sure that they're fully aware of change of circumstances. That's particularly the case where, in an offshore context, you may not know those beneficiaries very well at all. You're a professional trustee who's been set up, who is administering the trust from, say, Cayman or the BVI, but the beneficiaries are in the UK or further afield, and it's difficult. It can be difficult for the trustee to really understand what's going on, and they're under a tension there because of maybe a small fee that's been negotiated, and as against the costs of making sure that they carry out sufficient investigation and a dialogue with the beneficiaries, which obviously can open up a whole raft of points that they would then need to consider and possibly take advice on. And I think one of the points that we see from an offshore world is that there's a number of trusts that historically possibly have been run essentially as creatures of the settlor, where the settler's wishes are very much what drives the trustee decision-making process, or for example, a protector's wishes. And that's clearly it may well be you've got terms of a trust which are a directed trust, and that's, I guess, increasingly what we're seeing in an offshore context is the trustee is directed by settlor or protector or advisory committee to exercise its powers in a certain way. But if it hasn't got that, and it really is on the face of it a discretionary trust that the settlor is effectively pulling the strings behind the scene, that's clearly a difficult situation for a trustee to place themselves in. And certainly when we were considering the sort of beneficial ownership regime in Cayman, one of the questions there you have is whether you've got to try and work out who the beneficial owner is. And one of the tests there is who's actually exercising significant influence and control over the trust structure. And the trustees can place themselves in a very awkward position whereby on the face of the trust deed it's a discretionary trust, but if they've administered it on the basis that it's the settlor who's controlling it, and do they then disclose that they've got a tension there between their regulatory obligations and the duties that they owe to the settlor, which can place them in a very, very awkward position. So I suppose really what, in terms of practical steps, it is to be mindful of the fact that they increasingly will need to be held to account for what they've decided, and to make sure that they can demonstrate what the decisions they've taken have been taken for a proper purpose and within the scope of their powers, and that they've discharged those duties with care and skill, so considering relevant factors and not the irrelevant factors.
Thank you. I agree, and I think there are really two principal takeaways from that. The first is what you were saying around documenting the decision, and it seems to me that in the future trustees have got to focus not just on the sort of conclusionary stage, so making sure they have a nice, neatly drafted minute, but actually that there lies behind that minute a sort of decision log. So documenting actually the stages through which they went. And that I think then goes into, I think, the sort of second big takeaway from what you were saying, which is the extent to which trustees need to at least think about whether to consult and seek information from the wider beneficial class and not just from settlors. Because it seems to me that that's actually one of the biggest potential pitfalls here, particularly in relation to sort of trusts set up sort of new money from ex-Soviet Union and Far East, where the settlor tends to be a very influential figure, usually a man, and where trustees are sort of asked to make quite fundamental decisions about the trust without actually really knowing about even the financial position of the beneficial class. And of course, once one gets maybe 10, 20 years down the line, that sort of next generation will be grown-ups with their own families and their own financial situation. And so it seems to me making decisions in the ignorance of the situation of the members of the class is potentially difficult. But Ray, do you have anything to add from a practical perspective?
Yeah, it's, as an offshore, thanks, Ron. As an offshore lawyer, we're constantly asked particular questions. Can a trustee do this? Do they have the power? Is this within the bounds of decisions that are reasonable and unchallengeable? How do we make this unchallengeable? And one way, of course, of doing that is to say, well, let's ask the court, Public Trustee and Cooper. Historically, I've always taken the view that it's counsel's duty when a matter is clear to say the matter's clear, and to avoid inflicting the expense of a court application on the fund. But I tend to agree that the judicial tide is such that greater trustee accountability in terms of deliberation, the quality of decision-making process, is the way forward. I tend to agree with you, John, that there's going to be pressure, I think, on trustees' ability to just simply consult the settlor from time to time on letters of wishes or oral expressions of wishes. So all of that, I think, will come under pressure. You're absolutely right. But I think the flip side of that is that I think trustees are going to be more minded and often advised to go to court and get blessings. And of course, the more documented you have the decision process, the less cost there is in just adding on a court application to get some kind of blessing for it. I mean, if trusts, offshore trusts, really are going to become a much more process-oriented, much more heavily documented system of dispositive decision-making, and I'm not talking about the investment decisions here, I'm just talking about dispositive decisions, then if you've gone through all of that process and you've got all the material there, then it's actually a relatively little cost on top of that to take that to the court and say, this is actually what we're thinking of doing. Will you bless it? So I'd say that the quid pro quo is likely to be an increase in Cooper type applications.
I agree with that. And of course, the touchstone traditionally has been the word momentous. You're not supposed to seek a blessing unless the decision is momentous. And I think that that's been honoured in the breach often by offshore courts that have seen their job quite rightly as being there to assist trustees. Slight fight back in a couple of more recent Jersey cases, perhaps. But actually, it seems to me that you're absolutely right, and that I'm not sure in the future the word momentous should be seen as if it was a word in a statute. And if a trustee is in a situation where the trustee has a genuine concern that an important decision may be subject to challenge, then that trustee ought to be able to go to the court, and the court ought to be willing to exercise its supervisory powers to assist the trustee, even if the decision itself is not momentous. So I agree. Does anybody else have any other thoughts before we bring the session to an end? Jennifer?
I was just going to say that I think there is a danger that there will be more kickback from the courts, though, if if there's a perception on the part of the courts that it's seen as a sort of rubber stamping exercise that trustees want to go through for their own protection all the time without real consideration actually of whether it's a proportionate measure. And I think the reason why it was momentous in the past is because they are expensive, and it's a bit like preempting the litigation. And so it had to be some very significant decision if the court was going to spend time and there was going to be all the cost. Now, if you've got a trust that involves hundreds of millions and what you're doing is seeking to make an appointment that is going to be, I don't know, 10 million or something, in many, and you've got hostile beneficiaries, there's dissent amongst the beneficiaries and people are arguing, then plainly it's going to be reasonable, I think, to seek the court's blessing, partly because it's almost in the interests of the trust as a whole to nip it in the bud and preempt the costs of litigation. If you're almost certainly going to end up with litigation afterwards. But if actually people might be grumbling a little bit, but it's not clear that there's going to be litigation, and as I think, as Ray, you said, counsel has sometimes got to be clear. Trustees do always have the advantage of being able to take advice. And if they've had advice from a lawyer about what they need to do, and they can clearly evidence they can do that, actually the risk of somebody being able to sue them further down the line is pretty small. And I think the court won't look on trustees in that situation as being able to actually run the trust fund down. They've got to have an eye to the costs. So I think it's all about proportionality and thinking about it. And that even just comes back as well to the duty, to the extent there is a duty to make inquiries. I think partly what the court wants more than anything is just to see that the trustee has actually thought about whether they need to make inquiries. I think too often you see these sort of standard form minutes or resolutions, and there's just nothing to indicate that there's been any thought process at all. So I don't think trustees should get too worried about it having to be a very, very exacting process, but there's got to be some indication that there's been some thought given to it.
I agree. And I think one of the trends that I've noticed is the contested blessing hearing, or sort of semi-contested blessing hearing, which actually might serve in some situations quite a useful purpose, because it gives dissenting beneficiaries an opportunity to have their say and the court consider it without the trust and potentially a family being dragged into full-scale litigation. And if one can have that kind of battle, and that results in a blessing of a sort of a contentious decision, then that's not necessarily a bad thing, at least in trusts that can afford it. So thank you all very much, and thank you everybody for listening, and that brings our session to an end. Thank you very much.
Sure.